email that will advise members how they can access the program. So right now we're in the viewing period for the program that we did last month in October, so that's going to be available from November 1 through November 30th for viewing for credit. And for those of you who were not able to be here for that program, which had to do with social media and the kind of pitfalls that we encounter as lawyers when our clients are on social media, if you haven't seen that program, you should see the program whether you get credit for it or not, because it was an excellent program. There was a lot of really vital and useful information in that program. So you can view it online now for credit. Look at your email to see how to go about doing that. And again, this program will be recorded and will be available online for credit beginning December 1 and through December 31st. There have been a few glitches that have already been reported to us by some members about accessing that and how you get your certificate and things like that. So be patient with us. We're working through the glitches. We'll make sure you get the credit, so that won't be an issue. But report to us any problems you're having viewing these things online, because we need to know that so that we can, like I say, iron out the glitches. So today, you're here personally to hear about Medicare set-asides, which seem to be the bane of our existence as workers' compensation lawyers. So we have the experts here today with us. Some of you, maybe most of you even, will remember Rasa Fumagalli, who was around the commission for some period of time and is now with NewQuest, and her colleague Jennifer Szymanski, who are both here to talk to us today about Medicare set-asides. So thank you for being here.
So good morning, everyone. So I think what we're going to get started with is just a little bit of background on the law itself. And the reason why we do that is just to go more into what the law actually says versus what really has been built up in practice for the last 15 to 20 years. So as you may or may not know, Medicare, when it started in 1966, was always a secondary payer to work comp, and then also VA benefits. It's the black lung benefits. But it really wasn't until 1980, when they passed the Medicare Secondary Payer Act, that Medicare became secondary to the broad range liability, no fault Medicare. Excuse me. So the idea behind the Medicare Secondary Payer Act was really to keep Medicare from underfunding, right? To protect the funds themselves. So the act itself, you can see the site to it, the US Code site there, was really meant to protect those Medicare funds. So then in correlation to that, of course, Congress gave the Health and Human Services Department the ability to promulgate those rules. And so the regulations actually start at 42 CFR 411. So Medicare secondary payer itself really comes in three pieces. So the first piece of that is a reporting piece, which you'll hear everybody refer to it as the Section 111. Those are where all your clients, the applicable plans, are first figuring out who the Medicare beneficiaries are, and then once they're Medicare beneficiaries, what that reporting for the settlement or the ongoing payment of medicals is. So part one, the reporting piece. Part two are any of those past payments that Medicare has made, so the conditional payments. And we're going to talk a little bit more about that in detail in a few minutes. And then the third piece is always those potential future payments that Medicare makes. So that's really your set-aside realm. So in addition to the statute itself and the regulations, what we get from CMS are really memoranda. So I think the important thing to point out, though, is they're memoranda from CMS. So not law, as we know, but really more likely what CMS's interpretation of the statutes themselves are. So not necessarily 100% correct, but likely whatever arguments that they would make had they be challenged to the MSP. And then, of course, as you know, there are court cases that kind of direct us in how the interpretation is. And so the comparison is there for us to use, remembering that they're very, fact specific and jurisdictional specific. So just a couple of minutes or a couple seconds on the reporting piece itself. So there's really kind of two pieces of that. As we mentioned before, the first piece is just finding out who your Medicare beneficiaries are. And so that's for most companies of size, that's done by an electronic data transfer to CMS. There are people that still do it by paper. And then it goes back to them, usually quarterly, into their claim files. Remembering, though, that runs continually for the life of the claim, so if you start working on a claim and you're 6 months, a year into it, that claim file should still be getting updates. And so you should be getting, the claimants, the claim reps should be, or the claim reps, should be getting notification as that status changes to make you aware of what's going on. And then that second piece is, when you have identified those Medicare beneficiaries, you need to keep track of what those, the ORM and the TPOC. So ORM, the ongoing responsibility for medical, and then the TPOC is the total payment obligation to the claimant. What I will say here is, if you have any questions in this realm, CMS actually has a very good set of user guide. It's actually a user guide, but it comes in sets on its Medicare website. It is worth taking a look. They do a very good job of explaining. As it notes, this concept of the ORM and the TPOC are not new. We've been doing this. The first reporting really mandatory piece of it came in 2010, or the ORM, and then the TPOC itself, that total payment obligation to claimant, those cases that have to be reported if they're a Medicare beneficiary, those as of 1/1 of 2017 for liability, no fault, and work comp is all $750. So if it's the case settles for over the $750, it needs to be recorded. The reason why companies themselves are so concerned with the reporting is because there's potential penalties involved. So the potential is they can get fined $1,000 a day per claim. And so when that, in 2010, when that reporting requirement came in, that was everybody's fear of, we're not going to report something, we're going to be the poster child for, they're going to go through all of our files and start fining us for that. And then the other thing it just mentions is if you don't do the quarterly reporting, there's up to a $90,000 fine for a missed quarter. So that's the first piece. Ross is going to handle conditional payments.
Hello, everyone. So conditional payments are related to Section 111 reporting, in that once the ORM report is made, or you have TPOC reporting, Medicare is put on notice that there's another party, a primary payer, who's available to make payment or to reimburse Medicare for the payment. So all of these different pieces all work together for MSP compliance. So under the statute, Medicare, if they make a payment, their payment is conditioned upon reimbursement to the Medicare Trust Fund when you have a demonstration of responsibility from a primary plan. Because Medicare is not allowed to make payment where payment has been made or can reasonably be expected to be made under an automobile policy, a workers' comp policy, a liability, or a self-insured policy. When you have a disputed claim, though, and payments are not being made by the carrier, Medicare does make the payment so that the Medicare beneficiary can actually receive the treatment. But once Medicare makes the payment, you have to be mindful that this is a payment that they're going to seek reimbursement for. Hold on a second here. So this demonstration of responsibility is something that Medicare considers an entity that settles a case, whether it's through a settlement, a judgment, an award, or other means such as contract. They view that as a demonstration that Medicare is secondary and that this other plan is primary to it. So a primary plan or entity has also been expanded to include the beneficiary, the attorney, the provider, the physician, or other group insurance carrier. And it's this language within the Medicare Secondary Payer Act that actually terrifies everybody, because everybody's fear is that if this isn't handled correctly, I, the attorney, can be on the hook for this. If conditional payments are not resolved correctly, the Department of Treasury can also pursue double damages. And generally, this pursuit of double damages is based off of the Medicare conditional payment. There's also a private cause of action which allows, for example, Medicare Advantage plan to pursue the attorney for failure to reimburse their payments. So there is definitely exposure in terms of what will happen if you do not handle the conditional payment fees correctly. So let's take a look, though, at some of the limits on the conditional payments that are being claimed by CMS. So when the conditional payment recovery claim is directed to the beneficiary as opposed to the applicable plan, there is a discount that is taken to take into account the procurement cost. So even though you might have a conditional payment demand of, $3,000, the actual funds that will need to be reimbursed, assuming there's a 20% attorney fee, will be $2,400. So you're going to have this discount with the procurement fee. Applicable plans, when they're identified as the debtor, are not allowed to take a procurement fee. So there's no discount when it comes to that. The other limitation that you can have on conditional payments will occur based on case law. There's the Bradley versus Sebelius case where you actually had a state court apportion how much of the settlement should go for the reimbursement of conditional payments. When you have liability cases that people may be handling, there are also some additional ways of dealing with the conditional payments. You can have the fixed percentage reimbursement, which is essentially 25%, but this only applies in situations where you have a physical trauma that is the subject of the injury as opposed to an occupational exposure type of claim. The settlement has to be less than $5,000. You have to request to make the fixed percentage payment before there's a demand or the funds are reimbursed. And there cannot be any other settlement that's related to this particular claim, which would increase the value of the claim to something greater than $5,000. There's also a 3-year statute of limitations, which the implementation of the SMART Act put out. And this means that once Medicare is given notice of the settlement through TPOC reporting or other means, that they only have 3 years from the date of the notice to seek reimbursement of conditional payments that were made. There is a statutory 3-year claim filing limitation as well. As Jennifer mentioned, the reporting thresholds for under Section 111 currently are $750. This same reporting threshold applies for conditional payments. That means that if the conditional payments were less than $750, Medicare is not going to bother to seek reimbursement. In terms of the self-calculated ability to reimburse conditional payments, this self-calculated method is also available for liability claims. Once again, there's a limit in terms of how much the settlement is. The settlement has to be under $25,000. The claim has to be a physical trauma-based claim as opposed to an occupational exposure claim. The medical treatment has to have concluded within 90 days prior to submission of the proposed payment. And the accident is one that had to occur 6 months or more from the self-calculated amount. The next option, which is a hardship waiver, is something that may be available to your workers' comp beneficiaries. For the hardship waiver, CMS has very specific forms that need to be filled out to show that this person truly is struggling and they're not able to reimburse the conditional payment amount. If CMS does not have to pursue recovery through the Department of Treasury, the most that Medicare could ever receive in terms of reimbursement for conditional payments is going to be the amount of the settlement. It is not necessarily the amount of what the conditional payment is. So another thing that people should be aware of is the fact that Medicare Advantage plans, which are a form of Medicare, but they're Medicare Part C, they generally provide expanded coverage. They provide benefits under A, under B. They have a bit more. These plans are becoming much more aggressive in terms of seeking reimbursement. And there are several jurisdictions that have determined that these Medicare Advantage plans have the same reimbursement rights as a Medicare Part A or Part B plan. And it's just a good idea, given the fact that Medicare has indicated that the Part C plans have the same rights as Medicare, to be mindful of this, to try to resolve them in order to prevent issues with the Medicare Advantage plan recovery. Do you have a question? Self-calculated would be that, and this is for liability cases only, and so you would basically be looking at the amount of bills that you might have incurred, what Medicare has paid, and you can actually, as a beneficiary, you can pull up, you can register, you can go on that mymedicare.gov website, and you can actually see the payments that were made. So that is one way of self-calculating. And so it would be nice if this option was available for workers' comp as well, but it's not available at the moment. What I think people need to also consider, just back to the Medicare Advantage plan topic, is that although you can secure conditional payment information from the CRC or the VCRC, they do not give you the information for the Medicare Part C plan. So it's a good idea when you are taking a recorded statement, for example, or you're taking a deposition of a, well, probably not a claimant, because you guys don't necessarily do that, but it's always good to ask the claimant about the type of coverage that they have if they're on Medicare. You can also have different enrollments in the Medicare Advantage plans over the life of the claim. So you might have somebody who's in a Humana Medicare Advantage plan for the first 2 years while the claim is still open, and then they switch to a different plan. So you can get to this information by looking at a copy of their cards. You can also scrutinize the medical records to see who's paying the bills if you have denied the bills. So because of the fact that there's also litigation, or there's case law out there, which is the Western Heritage case, and it involves a Florida liability claim, you had a workers, well, it wasn't a workers' comp injury, you had a plan, the Western Heritage plan, agreed to settle a claim. As part of the agreement, the claimant was going to reimburse the Medicare Advantage plan. The claimant did not fully reimburse the Medicare Advantage plan, and the plan went after Western Heritage, and Western Heritage ended up having to reimburse this amount of money, even though they had already factored it into the original settlement. So it's a good idea to be mindful of these Advantage plans and to take the appropriate steps.
So you're saying that the Advantage plan comments that you just made only apply to liability, or do those also apply to?
I believe they also apply to workers' comp. So the case, though, was just given to illustrate the point that you're not safe by just contractually stating that somebody else is going to take care of it.
The one thing I would add about the Advantage plans is, take for instance my parents. My parents would both tell you they're on Medicare, when in reality my dad's on traditional Medicare and my mom is on the Advantage plan. And so remember, the Medicare card itself never changes. A Medicare card is a Medicare card. So both of my parents have the same Medicare card, it's the second card. So if my dad got his other insurance card, it would clearly say Medicare supplement plan on it. So he's got the traditional plan plus the supplement, whereas my mom would clearly say on it the Medicare Advantage plan. So just be aware that the people themselves often don't know what they're on, whether they're on traditional Medicare or the Medicare Advantage plan.
Where do you go to get the conditional payment information for each of them?
So for traditional Medicare, for my dad, when he gets billed, he actually will see it. It comes from the Medicare contract. My mom never interacts with Medicare. So she is with United Healthcare. So it all comes looking from United. And so when we go to look for liens in these, we literally need to know which one it is, because usually we're flipping over the card. If it's a Humana or United or somebody that we're used to working with, we know where to go. But if it happens to be in a state that has some unique ones, we're flipping over the card and starting with the information on the card to find the information.
Right, so those plans, they have a coordination of benefit phone numbers that you can contact, but you can't use the traditional method of looking for Part A and Part B payments, which you're getting through a request through CRC for these Medicare Advantage plans at the moment. Yes?
Hi, I know it's easy about Medicare, but I want to just kind of make sure that it's okay. Obviously, there's traditional Medicare, and you have a Medicare Advantage plan, and then you have supplemental plans. Is that fair to say? I mean, what are sort of the differences between a Medicare Advantage plan and a supplemental plan that you're offering?
Okay.
The gap insurance plan?
Yep.
Okay.
Yep. So Medicare supplement plan is something that actually covers things that Medicare wouldn't cover. So it's for those traditional Medicare people that have an additional coverage. So the Medicare Advantage plan wraps up that A and B, and usually the Medicare Advantage plans wrap up A, B, and D. So they've got the drug coverage in there. Whereas for a lot of the people that have the A and B, the supplement has some additional A and B information, but it's got the drug piece in it. Okay?
So, and just the mymedicare.com, the website, .gov, will actually show a Medicare beneficiary what payments have been made under Part A and Part B. So that is actually a very good resource if you're representing a claimant to sit down and work with them to pull the information from them. So, does anybody else have any other questions about conditional payment?
So I can get my head on this.
Sure.
I have to measure supplement your obligation. Medicare Advantage plan, not the Medicare.
No, you actually confuse terms. So if they have a supplement,
No, Medicare Advantage.
okay, yep, so if they have a Medicare Advantage plan, that conceivably, if they've had the Medicare Advantage plan the entire time, that's the only place you're going for the liens. But as Rasa said, it's possible they went on traditional Medicare, then went to one Medicare Advantage plan, then maybe switched to a different Medicare Advantage plan. So conceivably, in any case, if you have a 5-year-old claim, you could have 5 different places that you need to go.
You would not have a Medicare Part C plan at the same time that you have a Medicare Part A or Part B, because it will include it.
Supplements do
Supplements,
not suffer.
Not under the, I don't believe under the MSP, but there might be something within the contract that talks about reimbursement or coordination of benefits.
If someone's on a Social Security disability and is on Medicare because of that, does the person who's on Medicare because of disability have the same rights as an elderly person to still have the Medicare Advantage or supplemental plan?
yeah.
Like they're covered by Medicare, but if you have somebody, and when we're talking about the MSP obligations, that's limited to reimbursement of injury-related Medicare covered expenses. I mean, if you just have a person who doesn't have any injuries or anything, and they're on Medicare because of an unrelated condition, they're not going to have any reimbursement issues or anything, and they're entitled to sign up for any type of Medicare. Yes.
You probably go to the administration. You talk at some point about civil rights and you want to do this. They say that this is not how you operate.
Well, now that we have, oh, I'm sure, of course. The question is, how do you, if you have a conditional payment dispute and, well, the MSA is handled differently. So let's just talk about conditional payments. So if you have a conditional payment dispute and your position is that we don't owe this because this is unrelated, it's not compensable, and the CRC, the Commercial Recovery Center, I'm not sure if it's reimbursement, but Recovery Center, if they continue to say that we believe that this is part of your workers' comp claim, there's a direct right of appeal that applicable plans have, and it's also similar to the direct right of appeal that the beneficiary has. So there are different levels where you can appeal it to, and eventually you can get your way, you have an independent review by the QIC, you can have an ALJ hearing, and you can actually bump it out to the court system. So there are very distinct steps to follow, and your conditional payment notices and letters will outline the different steps to follow. You've had very good luck. So sometimes they will adjust it quite easily, but there have been situations where, the way that the CRC pulls, this data for their conditional payment demand is they have these codes that are sort of linked, like within a family of codes. So for a while, they had this grouper error that was going on, and they were just pulling very far removed codes. And it took quite some time for them to acknowledge that, this is a big grouper error. And so the process has gotten better, and I understand that there is going to be a new contractor who steps in January of 2018. There have been issues with the two different entities, the BCRC not being coordinated with the CRC. So you might have a situation where before the case settles, they're pursuing reimbursement of conditional payments from the applicable plan. But then you have settlement contracts that indicate, because you don't have a final number often, you have settlement contracts indicating that the carrier will remain responsible for reimbursement of any conditional payments for treatment incurred prior to settlement. But once the BCRC gets the contract, they actually sort of shift it off to the BCRC, and you may not necessarily have them catching that the carrier is responsible for it. So this new contractor that's taking over in January of 2018, supposedly they'll be able to set up a system where both entities, the ones that typically handle collection from the beneficiary, will be on the same page as the entity that's collecting from the plan. Yes, Greg?
And are the rights to the review and appeal the procedure available to the respondents or just to the petitioner?
They're available to both. And actually, the beneficiary had them to start out with. And the direct right of appeal that was rolled out, I'm thinking maybe a year or a year and a half ago, late 2015, seems like yesterday, it is now available to the CRC. So you have virtually identical recovery options or appeal options. Yes, Neil?
Sorry, but I want to get to the basic. Use Medicare, Part A and B.
Yes.
Okay. That's for the government, right?
Correct.
United States government. Then you have a supplement the Medicare recipients can buy over and above to get additional coverages, correct?
That's the supplement, the gap insurance.
Or it goes to FFP, I think. Right?
Well, there is.
Not C. The supplement is not C. Take C out of the mix. That's totally separate. Those are your Medicare Advantage plans.
That's what I was thinking. So, but the person that has Medicare is going to have Medicare, and they're going to have a supplement, perhaps, correct?
They could choose to seek a supplement, and they can also choose the type of Medicare that they enroll in. They can choose A, they can choose B. Well, I think automatically they get A, the hospital insurance ones, if they've worked enough credits and
The
they have
supplement
it.
is a policy, just to clarify, that you buy through another company, vendor.
Correct.
Okay. Now, an Advantage plan is purchased totally independent with another company altogether, correct?
That company, though, is getting paid by the government, so it's part of Medicare.
Okay, let's talk about what, that's interesting, but we are people that perhaps didn't know it,
Okay.
So if I had an Advantage plan, if someone came to me and said, get a Medicare Advantage plan, who would I talk to purchase that, and is that a private company?
It's a private company, for example, Blue Cross or Humana. They have contracts with the government to provide Medicare Advantage or Part C plans to Medicare beneficiaries.
Okay.
And they're paid sort of a per capita rate. So their payment is different than the type of payments that are made under Part A and Part B, which are generally fee-for-service payments.
Okay, but does a person that qualifies for Medicare, alternatively, as opposed to enrolling in Medicare, get an Advantage plan?
I'm sorry, can you please?
Like she said, I'm sorry, I forget your name.
That's Jennifer.
Okay, you said your mom was on an Advantage plan. Is she older, or is she Medicare eligible or not?
She absolutely is. And so here's the
So
difference.
to explain why a Medicare eligible person would get that, as opposed to simple enrolling in Medicare with a supplement.
Okay, so seriously, the insurance person that sits down with my parents each year goes through what is covered under traditional Medicare, the AB, and then goes through her various options of what she sells for Medicare Part C options. And she literally sits down with the drugs that my parents take and goes, here's what's covered under A and B for you. My dad's name is Ron. You, Ron. Here's what's covered for you, Kathy. Let's look at this type of Medicare Advantage plan. Here, Ron, are the drugs that are covered for you. Here's what's covered for Kathy. And she does that for various Advantage plans. And so they literally mathematically decide based on what they're taking and where they're going to the doctor or how often or whatever it is, what makes the most sense coverage-wise for them.
So now to the part that it probably was of great concern to all of us. If it's an advantage plan, we're going to get a subrogation or reimbursement replacement Blue Cross Blue Shield or one of those types of companies.
Correct.
It will not come from that.
That's absolutely correct, because
Okay.
Medicare is not keeping track at this time. You know, they know who is enrolled in what sort of Part C plan, for example, but it's not set up at the moment to provide that information to anybody who is seeking that information.
All right, so-
And to get on an advantage plan, just to be, everybody's on the same page, you have to be on Medicare. So if you're just like a 30-year-old who's not on Social Security disability, you know, you can't just go sign up for a Medicare Advantage plan.
So Medicare Advantage plan, using the word Medicare, it's really a private plan that you buy in lieu of Medicare.
No, that's not actually accurate. It is, a Medicare Advantage plan is sold by a company that contracts with Medicare. So Medicare is making the payments, the government is making the payments that will go towards funding the benefits you receive under a Medicare Advantage plan. So there's Medicare Part A, which is a hospital benefit. Part B is the outpatient services, physician services. Part C covers A and B and more. Part D is the drug plan. So the point in the litigation, and I believe In re Avantia was the first case that dealt with a Medicare Advantage plan, was that because the government is contributing to paying for the Medicare Advantage plan, that it's not right for the government to have to be stuck with these injury-related expenses. So there's a CMS memo, there are other regulations that talk about the fact that a Medicare Advantage plan is Medicare. So it's just harder to get the information because it doesn't have the centralized database the way that you can get for Medicare Part A and Part B conditional payments.
I just don't understand why the government's paying the Advantage plan policy insurance, and then we're going to pay private company.
You're going to reimburse the part, you're going to reimburse the Advantage plan.
Yeah, but
You say the government contributes to the
Yes.
and they're paying premium.
Yeah, so they're essentially going
And
to,
then the company pays the bill.
right, so they're essentially going to like Blue Cross Blue Shield and saying you have blank million Medicare people that are signed up for your Part C plans. You get X amount for each one of these people. So now you have to give the same services that you would get under A and B, but they can add services. So the bonus of going with the C plan is it has to give you the coverage that A and B would give you, but you're actually buying the C plan because it's doing something else for you.
So the thing too is that about these Medicare Advantage plans, and that's kind of a big issue, is that, well, they're not really out the money, so why should we be making these private insurance plans wealthier once they're contracting with Medicare? And there's a whole bunch of arguments that say, even though, the courts are finding that these Medicare Advantage plans actually have the right to reimbursement, we should appeal it up and take it up to the highest level because it doesn't seem right. And the thing is that these Advantage plans, because the amount that the government decides to pay for them is based on the characteristics of the pool that is enrolled in them. So and there's a lawsuit that's out there that actually talks about the way that they were not adjusting these risks correctly. So if you can show, for example, United, that most of the people in this pool that are signed up for Medicare Advantage plans, that they are at great risk of having serious medical expenses. Therefore, they will be able to get more money, this greater capitation fee from the government. So they'll be making more money. And so what they were doing, these auditors, they were sort of upcoding. So they were looking at the worst diagnosis that this person had like 5 years ago, and they were not taking into account the fact that well, this condition is stabilized, or that this condition is no longer here. And so these companies were making more money, and then Medicare sued them. And I'd be happy to share some of this information in terms of, sites and so forth later. But, so it's a big, it doesn't seem right that you're going to be using some of your settlement funds theoretically to reimburse this private plan. But because Medicare is paying for it through the capitation, that's the setup. Yes, Mark.
Has there been any consideration to grab this whole kind of, MSA, this whole reimbursement, and just institute some type of, surcharge on premiums or settlements, and just avoid this massive cost in
That discussion has taken place when they were talking about liability MSAs. Several years ago, they had this, the Medicare Secondary Payer Act also applies to liability, to no fault, to workers' comp as well. So they had this advanced proposed notice of rulemaking or something, where they were trying to figure out what they should be doing. And some of the things they considered was, just have everybody, if your settlement is under 25 grand or something, just forget about it. Don't worry about it. Then they had other options that they were considering, which was, I think some of them were just maybe doing a type of different reimbursement, whether it was like a flat percentage or something, send the money. So all of the things that they considered, though, nothing really panned out. So what you basically have, though, is you have an aging population. You have the Medicare Trust Fund, which is being depleted. Depending upon what happens to healthcare down the road is, you're eventually going to have a lot of people who have paid into the Social Security system thinking they're going to have these benefits. And they need to somehow jack up that trust fund. And the way they're doing it is through the Medicare Secondary Payer Act. So, yes, Ron? Yes, and that is right here. So, if you have, you're asking whether we would recommend that a person sign up for a Medicare Advantage plan or just regular Part A, Part B if they have. So, and then of course the question is his disability due to an injury? Is it like a workers' comp injury, for example? All right, so the thing is, and this is actually a great way to get into that, and the thing is that what you have to remember with the Medicare Secondary Payer Act, and I know that it's, number one, it's probably really boring to most people. People hate dealing with it because it slows down settlement, it's a burden, but if you keep the big concept of what you're supposed to be doing in mind, it does help you figure out how to analyze it. And the whole point is you're supposed to avoid a cost shift of injury-related Medicare-covered expenses to Medicare. So in your situation, if your person is going to need a whole lot of treatment that is conceivably injury-related, depending upon what is going on in the case and the amount of your settlement, it would be reasonable to apportion some of that settlement to cover or prevent future conditional payments by Medicare. And there are a lot of different ways to do that. So, as Jennifer had mentioned, MSP compliance does have three parts to it. There's Section 111, there's reimbursement of conditional payments, which are payments that are made after an injury but before settlement. And then the next piece is the future conditional payment, which is a way to kind of think about it, which is also known as a Medicare set-aside. And just so we're, even though Jennifer and I work at the moment for a vendor, we really don't have any skin in the game in terms of what you are doing. This is your choice, it's your case, you either represent the claimant, you represent the insurance company. The point of our, what is reasonable consideration is to let you know that there's more than one way to do things. So let's, people a lot of times forget that your MSP obligation is something that's defined by law. The CMS memos and all that, as Jennifer pointed out, are just agency memos. You don't have to go through that whole CMS voluntary submission maze. If you choose to take that path, which might be something that you have to do for whatever reason, you know, you have to follow their guidebook. So that guidebook might have some benefits, but it has a lot of things that are not necessarily in everybody's best interest. So if you think of MSP compliance as, do I follow the law, or do I go into the CMS, you know, review maze, you can figure out what you need to do in your particular case. So what we have found is that, you know, everybody knows a little bit about Medicare. Some people know a lot about Medicare, and it is important as attorneys, as this preamble states, that you have an informed understanding of your client's legal rights and obligations. So this means that even if you don't really care about Medicare, you need to figure it out and have a good enough idea of what the Medicare Secondary Payer Act actually requires you to do. The next thing is that you have to zealously assert your client's position, not necessarily your, oh my God, if I don't do it this way, I might be sued for double damages. You have to think about the client, whether it's the claimant or it's an insurance company. And you also have to seek a result that's advantageous to the client. So if you keep these things in mind, and you keep in mind that the whole point is to avoid a cost shift of injury-related Medicare covered expenses to Medicare, you can sort of get a better framework of how you're going to handle your case. So Medicare set-asides are a legal fiction. There isn't a single law out there that says you have to have a Medicare set-aside. You have a statute that indicates that Medicare is a secondary payer when a primary payer is available and there's a demonstration of responsibility. There's nothing that says you have to have an MSA. You have the regulations which talk about Medicare being a secondary payer, and then you have those CMS memos that said, hey, it's a good idea to have a set-aside when you are closing out your injury-related care. And in the 1980s, early 1990s, you know, everybody came up and they did all these submissions to CMS because they thought this is what you have to do. And then with time, you know, people are starting to focus on alternatives. There's a greater push to, well, if CMS says I have to do this, but they also say it's purely voluntary and there's no statutory requirement to doing it, you know, people are thinking, well, why? Why am I doing it? And there may be good reasons to do it, but there are a whole lot of other reasons why you should consider other alternatives. So, okay. So, over time, there's been a greater degree of attention to alternatives. You actually have, you know, relatively large companies who have decided we are not going to take that CMS submission route. We are going to do evidence-based medicine analyses in cases that warrant them. We are going to minimize the risk of any issue, and we are going to have our own internal non-submission protocols, programs. And these non-submit programs are something that we have seen are gaining in popularity. The National Alliance for Medicare Set-Aside Professionals is NAMSAP, is a trade group that deals with Medicare Set-Aside professionals. Over the past 2 conferences that they've had annually, they have had panels talk about to submit, to not submit. So CMS submission is not the only game in town. So we are going to discuss some of these various alternatives. But, and I believe that Jennifer is going to go over these.
So before we kind of get to the concept of what other types of non-submission is, let's talk a little bit about like the types of MSAs, because it is not just an MSA as an MSA as an MSA. So the first type is the one that you guys are most used to seeing. It's called a commutation MSA. So that is just your full funding of your injury-related Medicare-covered medical. So the next one is a compromise, and that's really an apportionment of when you have some denials or disputes in the case. We're going to talk about that now in depth a little bit more. So partial waivers, so if you have some accepted conditions, it's the fully funding of those accepted conditions, and then it's going to CMS to get that waiver for those denied conditions that you haven't made any payments for. So too the same thing with the $0 MSA, instead of just the partial, it's the full case. The one thing I was going to make a comment on for those $0 feature waivers is this new reference guide that came out in July of this year seems to indicate that CMS wants a little bit more information on those. So not just clean payment records on those cases, but they also want some explanation for the reason for the denial in the case. So the nuisance value cases, we find that most of our clients have some level, a lot of them hover around $10,000, $15,000, some level that they're comfortable with explaining in the documents, you know what, we're just really paying to make this go away. This is really a nuisance value settlement. There is no money there for the future fees. And then the next one is what Ross was talking about before, which is a more evidence-based standards of care allocation. And then those can come, with or without some type of indemnification and hold harmless on the back end. We're going to talk about that in a little more detail just a second. Yep, I know, we need to speed it up. So Rafa mentioned this before. This slide just really talks about the references to CMS, continually saying it is a completely voluntary process. But the thing to note is if you're going to enter the voluntary process, you're playing by their rules. You're going to fund the way that they want you to fund, which is essentially, if it's possible, it goes in the MSA. If they look at diagnostics, MRIs, x-rays, PT, you're funding at the level that CMS puts in their checkboxes, not on what's reasonably likely to occur. So workload review threshold, you guys I'm sure know these. If the Medicare beneficiary, it's a total settlement amount over $25,000. If it is in that reasonable expectation category of becoming a Medicare beneficiary within the next 30 months, it needs to be over $250,000. So CMS submission completely voluntary. If you are going to submit, it has to hit one of these categories. That they will clearly state, not a safe harbor if you're outside of the categories, but these are the only two categories that they will review. You want to talk about that?
Sure. So really, because we are somewhat pressed for time, I'm going to assume that most people really are familiar with what you have to do to submit a case to CMS and what you're going to end up with. You have to meet this total settlement amount. You have this workers' comp MSA reference guide that has a ton of things that you have to include in your submission. A lot of times you don't have that information. You have to get it from your carrier. Your carrier's computer system cannot generate it in the format that CMS wants it. So there are a lot of hoops that you have to jump through to get to the CMS submission. When you give them everything they need, 30% of the time you're going to end up with a development letter because you have some brand new clerk who is looking at the stuff and doesn't realize that the reference guide really doesn't mean that you have to submit your reserve information, which means that you go back to square one of trying to explain to them that this is an issue. So it's a very burdensome, though at times appropriate, process. If CMS comes back, they can either accept the figure that was submitted, they generally increase the figure that was submitted, or they can occasionally come up with a lower figure because they use different CPT codes and pricing. And what is very important to consider, and this is generally on the back of all those determination letters, and it's also in the updated reference guide. People think that because they have the CMS determination that they are home free, that everything is fine, claimant's not going to have any issues. That's really not the case, because Medicare is only going to become primary upon proper exhaustion of those MSA funds. From recalling my workers' comp insurance defense experience, I can say that probably half the people that I dealt with in terms of claimants would really not know whether Lyrica is Medicare covered and should properly be expended from the MSA funds as opposed to the gabapentin. So there are different things that you have to keep in mind if you are self-administering an MSA. You have a CMS determination, you fund the CMS determination, claimant blows it, paying for things that they think the comp carrier paid for, therefore the MSA should pay for. Medicare does not accept proper exhaustion. They might make a conditional payment. They're going back to the claimant saying, reimburse us, you should have paid this from your MSA. So there are many things that you need to consider, and Jennifer is going to go over the rest of that.
We do. So really, again, the point of today is all about what are your options? What is a reasonable consideration of Medicare's interest? So, one option is to go through that kind of CMS maze of that voluntary process, but there are other options, one of which is, doing nothing. And not a position that most of the, at least large insurance carriers or even the regionals, tend to agree, mostly because, remember, you're also doing that Section 111 reporting, so it's on Medicare's radar. Also, you have joint and several liability for the conditional payment piece. And Russ also mentioned there's a possibility of the private cause of action. So it is an option, in cases perhaps where if you, don't have any future treatment, maybe it's not an issue.
Going to trial, you have a trial order, full and final, issued after hearing on the merits. They say it's not, this treatment after this date has nothing to do with this work-related injury. So there are legitimate times where you're going to choose to do nothing, but you have to have a basis for your action.
So the second option is to basically follow CMS's process, right? Follow how they would fund it, but just simply not engage in their voluntary submission process. So that's faster, right? You have the same MSA that you would submit to CMS, but you're ready to go ahead and settle. The issue, the potential issue with that is, again, remember, you're funding at that CMS level. CMS generally, if you have a laundry list of this surgery, that surgery, it could be this, and oh, by the way, if that doesn't work, we could do a spinal cord stimulator. You're buying that in the CMS determination. So again, I mentioned the diagnostics, another place where they kind of force you to fund not at what's most reasonably likely to occur, but what they think it should be funded at. So you can, at your option, go ahead and follow CMS and just simply not engage in their voluntary process. So another option is to follow this more standards of care, evidence-based medicine approach. And so what we generally see with those is about a 35 to 45% reduction in the MSA amount for that same reason that I mentioned before. You're not funding at that anything is possible. You're funding at what is reasonably likely to occur with this claimant based on standards of care and the evidence-based medicine. So that's still both medically and legally defensible. It's just not funding at their amounts. So the bonus on that is that amount, that more reasonable amount, is more likely to end in a settlement, and usually a faster settlement at that. And then I mentioned before the types of MSAs. So there is my pretty chart. Okay, so the concept of the compromise is really doing an apportionment of the future medical. And there's actually one of the regulations that's included in your packet is 41147 is what it's based on. So the thought being, we take the economic picture of the future medical, the future Medicare covered medical, the MSA amount. We look at the rest of the economics of the case, and we come up with an apportioned percentage. So the example itself, I did some just really even numbers. If we had a $50,000 MSA, then we actually asked some additional questions for that exposure information. Let's say then that exposure information was $100,000. So we take the MSA amount over the total exposure, so MSA plus that exposure, so 150, and you would come up with a 33.3%. So what you do then is, you take that same 33% that you came up with, and you just scale it down to your case. So what we do then is, take your total settlement, minus your attorney fees, if there's liens involved, and you get a net to the claimant. So what you're looking at is after you complete your percentage on the big pie chart, what the full economic picture looks like, and we came up with a 33, we scale it down to the actual settlement amount, and we take 33% of what the net to the claimant is.
And what these charts show is that there's no attempt to cost shift injury-related expenses to Medicare in your settlement. You're doing an objective, what is like the total potential exposure if you go try a case before the most petitioner-oriented arbitrator out there, and what is the relative value of all these different pieces? And when you are not trying to maximize one to the detriment of Medicare, it is a legally defensible allocation, which is a compromised allocation based on 42 CFR 411.17, and it uses Medicare's own formula in the context of past conditional payments, which are being applied to the future.
Andy, I'm sorry. And let's get through the last slide, and then Andy, you can answer everybody after. I'm so sorry. But I know everybody wants to understand, if you engage in one of these alternatives, who bears the risk, and what about hold harmless and indemnifications? I want that to be addressed. I'm so sorry.
No, we'll answer your question. Okay. So when you're thinking about, well, what should I be doing? If you choose whether it's a traditional CMS submission or if it's one of these alternative approaches, you should think about administration, because administration of the funds really are the things that are very important in terms of the claimant not having issues. The current reference guide says that if you are jumping through their hoops, they are recommending professional administration. If you do not submit, you can still have professional administration to add to this extra layer of protection that the money is being spent properly. You can also have something that is a step above self-administration where the claimant is doing their own thing. It's called self-administration with support services. You basically have somebody, an administrator, holding the claimant's hand as they figure out, can I use the Medicare set-aside funds to pay for this? So these are things that should be discussed and contemplated when you're having your settlement discussions. When you're thinking about who bears the risk, if you're going to stick in your contract that the claimant is responsible for reimbursement of all conditional payments incurred prior to settlement, first off, you should know your opponent. Like, is your opponent somebody who you know will actually follow through with this? Or is this a situation where it's unlikely that this person is actually going to take care of it, which means that your carrier may be stuck holding the bag despite the contractual language, because Medicare can go after the primary payer, which would be the applicable plan. You also have to consider, if you do nothing, for example, you shouldn't just do nothing because you don't feel like it. You should do nothing with a legally sound basis for that decision. You should have proper documentation in your file. You should have whatever, you know, if you're not allocating because you have a full and final court order issued after hearing on the merits, you should stick it in the file, you should refer to it in the contract. The whole point is avoiding a cost shift of injury-related expenses to Medicare. When you have a situation where you've disputed the case from the get-go, the compromise allocation allows you to give Medicare's interest reasonable consideration in a disputed claim, and you're still settling it for whatever great deal you can get as a defense attorney. But you're giving Medicare's interest consideration. You know, there are products that have insurance associated with them. There are products that have hold harmless and indemnification agreements with these non-submitted MSAs, which means, and in some of them it means that if there's ever a challenge or an issue with conditional payments, that some other entity is there to protect the claimant, whether it's the claimant or the carrier or the agents of the claimant as an attorney. So there's more than one way to get to MSD compliance. And just because you always took that scenic country road via CMS review, there are highways. There are different ways to get there. So thank you for your time. And I don't know if you have anything to add, Jennifer?